I'm honored to be here, and spoiler alert, what the title means is sick means I meant to spell it that way, and patents have gotten rolled by big technology companies. And by that I mean not pharmaceutical companies, not Qualcomm, but the traditional folks who are lobbying against patents. This means that technology entrepreneurs who need effective patent enforcement are now out of luck. And as society at large is losing out from innovations that have not been founded, funded, or grown. This is a continuation in part. I strive to make my presentations novel, useful, and non-obvious, but I do recycle some prior material. But there's much that is new and improved. Just out of curiosity, how many of you have seen me give a speech before on patent stuff? Okay, a couple of people. So some reruns, but a lot of new. Since one can generally read much faster than you can listen, that shows that you can listen faster than most people can speak. And so since spare mental cycles tend to lead to multitasking and lower retention, I try to use those spare cycles up and rely on the Doppler effect, which is the tendency of stupid ideas to seem smarter when they come at you rapidly. Esquire magazine had an article in 2015, as did others, which is that the name Gary is going extinct. Yet I note that 2/3 of today keynoters are named Gary. So I want to thank the authors here for giving us this swan song. So I'm a venture capitalist. I've invested in over $500 million in venture capital in the past 35 years, over 125 companies, over 100 venture funds. I'm not a lawyer, but I've kept many well fed. I'm an inventor or co-inventor on about 17 issued patents and involved in some amicus briefs at SCOTUS, and have no interest in any troll, PAE, or entity behaving as such. My expertise is in how VCs consider what to invest in, the role patents play in that, how patents affect the success of small companies. They don't matter that much to software and internet companies, but they do to most other technologies. And the National Venture Capital Association board had software and internet types who didn't like patents. And so, unfortunately, they were mild in their criticism of the America-Invents Act. But they have since changed in 2014, which is a nice thing. I'm not a fan of PAEs. I was a chairman of 2 companies in 2015 when I sold them. And in the prior 3 years, both had been challenged a total of 3 times, fought all 3, and they cost $100,000 per. And despite that experience, I don't believe anti-troll bills would be I believe anti-troll bills would be more harmful than helpful to legitimate patentees. So there's a baby and bathwater issue. It would make it harder to fund startups that need patents because it would make it harder to win cases. Much of PAE activity is actually just and fair, and I have a personal experience with this. And so it's a false premise that all trolls are bad. An example of a just PAE is I invested in a company named Hybrid Networks in 1994. They invented asymmetrical cable modems. The cable industry subsequently created the DOCSIS cable modem standard incorporating some of their technology. The company moved to wireless modems but ultimately failed, and now all cable modems are asymmetrical and use their technologies. And the assets of that company went to debtors, and then the debtors sold the IP to a PAE who sued the large MSOs, stands for multiple system operators, i.e. cable operators, who offered over $100 million to settle, but the PAE declined. It went to trial in Eastern Texas, and then the PAE lost. And the result is that the thieves won. I had no interest in the outcome, but it's interesting to have a retrospective on that, which is I knew that this would be a huge market and there was a risk of IP theft, but I was induced to invest because of the faith in the patents as a backstop of value. And so did Exile and Sequoia, who are leading venture capitalists. The lenders lent them $5 million based on the notion that those patents would have residual value. For those patents to have full value, they need to be saleable to a third party, like a PAE. It's hard for venture capitalists to fund patent lawsuits because, for example, if you're suing a company that you then expect another of your companies to be selling to, then that can lead to difficult negotiations. So this is not something that venture capitalists want to fund. So if practicing the patent was necessary to have full rights, then they could have continued to make a few modems. But generally, and I'm mentioning this because from time to time there are attempts to tweak legislation to limit transferability or to have the rights of patents be less transferable and less enforceable if you're not the original inventor. And I think those are ill-conceived. From a fairness perspective, the cable industry's cable modem cash flow is now over $100 billion per year, and their market cap is many times that. The video and phone businesses' cash flow is approximately zero. If the PAE had won, the entire industry would have paid maybe $200 million for that technology, and they still would have been a big winner, even if they had settled for a large sum. But that company was forced from being a practicing entity to be a non-practicing entity due to the theft. And I would have not made that investment if the patent regime had been what it seems to be becoming. If the cable industry had been punished for theft, that would tend to lead to better behavior. And I'll get back to the subject of behavior a little bit later. It's worthwhile to do a taxonomy of trolls / PAEs, patent assertion entities. Not all are alike. So I'd call the prior example a just or fair PAE, and other examples are Edison, Dolby, universities, and labs are also non-practicing entities, NPEs. But trolls, I use that term for the folks who do nuisance suits, where they're looking to settle for less than the cost of litigation, and often they, what they're seeking is, they're seeking to settle. They sue with patents that either are useless or don't really apply to the defendant. And the lowest form of life are the letter mills folks and on fax machines and Wi-Fi's and so forth. So they're not all the same, but they're tarred with the same pejorative. And it's also important to note that not all startups need patent. PTO takes over 3 years to issue, which is too slow for many businesses like software and internet. And patents needed for innovations that are easy to copy once some pioneers shown the way are the ones that need it most, like medical devices and biotech and energy and clean tech and Internet of Things and semiconductors, electronics, optics, like LiDAR for automated vehicles and most tangible things and many others and many things that are yet to be invented. So there's a long, long list of things that really need patents, but not software and internet, which are the biggest companies in our economy, which are the ones who are lobbying to destroy the patent system. Incumbents tend to like incumbency. Let's fancy that. Joseph Schumpeter coined the phrase creative destruction, and a new technology, usually from new entrants, swept away the old and therefore improved things. Lo and behold, incumbents don't like the destruction part of that phrase. Patents are hugely important for this, but they are declining in importance because of the weakening of the system. Now, some industries are net defendants. They don't use patents to achieve their market power. They may have a lot of patents. That doesn't mean that they use them in any meaningful way. Examples of that are in the software and internet space, Google, Oracle, Salesforce.com, etc. Intel has patents, but their historical market power comes from the huge economies of scale. An example of wafer fab cost, TSMC recently spent over $18 billion building a wafer fab. Not many people can. Banks who got sued for using infringing image check processing technology, they don't invent much, they just use others' technology. Same, big consumer electronics companies, most innovation happens at the semiconductor level. So restaurants who receive troll letters, retailers who get sued for selling infringing technology imported from China or not imported from China. Cable and telephone companies, their market power is due to their franchises. These are natural monopolies, and once the initial network is in, it's hard for anyone to compete. So these are examples of companies that don't need patents for their market power. So they find themselves being defendants, not plaintiffs, so they'd rather just see all that go away, despite the cost to our economy and our lives. So this unholy alliance came together to, quote, fix the troll problem. They parade poor, innocent victims of trolling, small entities which fools Congress into sympathizing, these the shills, the victims who are not the same as the ones paying over $1 billion to lobby this issue over the past dozen years. The trolls are the necessary boogeyman to trick Congress, which they've successfully done. It's important for objectification and loss of rationality to be effective. And so the troll meme seems to be supporting a great deal of artists. It's really actually amazing how much they have been funding the artists to come up with these. And the list goes on and on and on. At least they support artists and respect copyrights. Or do they? This is one picture of a patent troll. And here's a clear knockoff. Not the same artist, but a clear imitation. You know, there was a Stanford conference co-sponsored by Samsung Electronics in 2015 that had this patent troll. And here it's hard to see, but this patent troll is stamping on the word innovation. At the time, John Hennessy, Stanford's president, was on the boards of Cisco and Google. Coincidence? Or maybe it was Mark Lemley? Who knows? So they have conducted a publicity campaign. People in Shrek costumes handing out flyers outside of Union Station in D.C., posters on the walls of National Airport that are anti-troll. You can be sure that these were not paid for by the small innocent victims of trolls whom they are claiming to be defending. That was mostly the Consumer Technology Association, whose membership are companies like Samsung and other mostly Asian consumer electronics vendors whose, as I said, whose innovations are mostly on the semiconductor side. So this was willfully blown out of proportion. Agent Orange in the White House famously said, "I have the best words." And here's one for you. Sophistry, which is the use of fallacious arguments, especially with the intention of deceiving, or a fallacious argument. And here is a good example of such sophistry, the White House's 2013 PAE report. It showed the hockey stick growth of patent lawsuits by patent assertion entities. They did not actually say that this was as a result of the legislation that they passed, the America-Invents Act. They just painted as an out-of-control problem that they had to do something to pass more legislation. Basically, in that legislation, there was a provision meant to harm trolls that required that suits against multiple defendants be filed separately, where previously they had been filed together in a single suit, and that caused an artificial spike. So the number of suits went up, but the number of defendants did not go up. The number of litigants is actually the smallest since before 2018. The White House's report's authors knew this would mislead, but they withheld that information. Mark Twain explained this well. Figures never lie, but liars always figure. Google and other big tech companies had undue influence on this administration, and I'm a Democrat, so I'm embarrassed to say that. But so Lex Machina, who compiles great statistics, actually measured plaintiff-defendant case pairs. And this is what the actual patent litigation looked like. Oh, and by the way, I'm happy to make these slides available to everybody afterwards, hopefully through Bruce, and so you don't need to take copious notes or photos, but feel free. So anyways, this shows that the level of lawsuits in this country has been relatively flat, with the sole exception of a spike around the time of the America-Invents Act becoming effective because of a certain regulatory artifice that I'll address later. And so here's with 5 more years of data of the same source from Lex Machina, and you can see that patent lawsuits are continuing to decline. And here's a view of that on an annual basis. And I note that 2019 was 50.2% the number of lawsuits of 2011. So from a longer-term perspective, this shows patent lawsuit filings in U.S. district courts from 1923 to the present. This is data compiled by Ron Katznelson. He notes the increase this is a quotation from that White House report. The increased prevalence of PAE suits and patent suits in general in recent years stands in contrast to the 20th century, when suits for patent infringement were relatively rare. Well, you can see just how much bullshit that is. So contrary to this allegation, there's been no real increase relative to the relevant indicators. So here are patent suits as a fraction of all civil suits in U.S. district courts. Note the spike at the end was due to the AIA. And here are IP lawsuits per $1 billion of GDP product in the U.S. district courts. The blue line are copyright, the red trademark, and the black patent. And so you can see there was a great deal more such suits in the early part of the last century. Also interesting that in the last 15 years, nobody complained about the copyright litigation explosions. But anyway, another topic. Here are patent lawsuits as a percentage of patents in force. The blue line is the number of patents in force. It's interesting to note that litigation is a function of new inventions. There was some wonderful research done by Zarina Khan of Bowdoin College, who collected data going back to 1790 and showed that litigation rates were much higher in the 19th century. And every major new invention led to a wave of litigation among the new entrants. So here is U.S. patenting rates and grants relative to the population. Here are patent litigation rates from 1719 to 2000, reported as lawsuits as a percentage of total patents granted. As you can see, this was highest around 1850. Here is total litigation relative to the usage of the telegraph, and they divided litigation by millions of messages sent. And this is similar data for the telephone industry. It peaked around in the 1890s. Automobiles, their patent litigation peaked in the early 1900s, and so forth. Each new technology leads to a wave of litigation, and as there is a land rush for new entrants, and then litigation is how the players negotiate their respective positions and combine. And as the rate of innovations go up, so should our society's level of litigation. And also, you would expect, as the economy's technology intensity goes up, you would expect more litigation just from that alone. And the two should be multiplied against each other. So you expect litigation to go way up as a result of all the new technology and technology's growing importance in the economy. Yet, it seems to be missing. So it raises the question, is that good? So if the licensors and licensees work things out and can avoid the courts, then yes, absolutely, it's good. But if it's because companies copy patented inventions and then usually get away with it with minimal expense and embarrassment, no, I would say that's not good. And it is the latter, and it's resulting in hopelessness, which is why suing rarely results in justice, so fewer are bothering, which is why we're seeing the decline. Now, I would argue that litigation is actually the wrong measure of the health. As Albert Einstein said, not everything that counts can be counted, and not everything that can be counted counts. What's most important about a patent system is inducing the right behavior without litigation and getting entrepreneurs and investors to take startup risks, getting incumbents to buy innovators and not copy them. The right behaviors don't really show up in the statistics, and litigation is the proverbial tip of the iceberg. And what's below the water, which is so much more important, is, it's hard to read, but it says copying versus acquiring or licensing, and on the right it says a sincere form of flattery. Corporate behavior is most important, and suits are a minority. And on the bottom it says hard to measure the size of the iceberg, but the direction is clear. So the disrespect for patents is growing. There's unabashed copying, which is often euphemistically called efficient infringement. Another appropriate quotation, when people are free to do as they please, they usually imitate each other. Large companies are ignoring innovators more, which is a result of growing difficulties in enforcement. There's a better chance of the defendant winning. There are many new ways to delay the outcome in the PTAB, which stands for Patent Trial and Appeal Board. And infringers are emboldened by the constant chipping away at the probability of plaintiff success. And the Supreme Court is also chipping away at it too. A word on the PTAB. This is also a graphic from Lex Machina. It's kind of hard to read, but it shows all the petitions, shows what fraction are instituted, meaning going to trial, and then the outcomes of the final decisions. But ignoring the percentages for a moment, the PTAB adds at least a year to patent trials just because of how most courts stay at trial pending the outcome of the PTAB challenges. But even worse, you have PTAB pylons, which is where the defendants are using their balance sheets to overwhelm plaintiffs at the PTAB by filing multiple petitions, even against the same patent, violating the congressional intent of the legislation in the AAA that created it, ganging up with others to all file separate petitions against patent owners. And when inventive companies that compete with incumbents are attacked this way, it ought to be an antitrust violation. In the past, antitrust has played an important role, not all positive. In the 1930s to the 1980s, there was this doctrine of patent misuse, and due to the over-application of that led to the U.S. losing the auto, TV, and VCR industries, among others. In Reagan's Commission on Competitiveness in 1982, that led to changed antitrust enforcement on this and the creation of the CAFC, the Federal Circuit. We've had great innovation since. It's not all rosy, it's not all that simple, but that is an important headline. But the FTC, the Federal Trade Commission, misunderstands the role of patents. So a patent is a right to exclude, which sounds like a monopoly, but the main value is for new entrants to challenge the incumbents. So it's pro-competitive, but they haven't exactly gotten that message. Also, former FTC patent person is now at Google. So this battle has many fronts, and this is yet another. On efficient infringement, so many big companies consider it their duty to not talk with patent owners. And others say, you got a problem with that, so sue us. George Bernard Shaw said, when a stupid man is doing something he is ashamed of, he always declares that it is his duty. We are moving back to the pre-patent era, back before we had patent rights, where might made right. Ben Franklin said in a letter in 1755, one would not, of all the faculties or qualities of the mind, wish for a friend or child that he should have that of invention. For his attempts to benefit mankind in that way, however well imagined, if they do not succeed, expose him, though very unjustly, to general ridicule and contempt, and, if they do succeed, to envy, robbery, and abuse. That's where we're heading. And Abe Lincoln, the only president to have held a patent, said, before the adoption of the United States Constitution, any man might instantly use what another had invented, so that the inventor had no special advantage from his own invention. The patent system changed this, secured to the inventor for a limited time the exclusive use of his invention, and thereby added the fuel of interest to the fire of genius in the discovery and production of new and useful things. How quaint. The notion of the Gini index is a way of measuring an inequality in a given country or society. It's usually applied for individuals, but little is said about inequality among companies. In the last decade, bankruptcies and exits have exceeded the formation of new companies. So business dynamism is actually down. And this is, I allege, is one reason, which is the opposite of China. Historically, IP was stolen from China. Silk making and porcelain making were technologies that our spies, we, the West, snuck out of there to Europe. And I think that's part of their narrative for rationalizing all the IP stealing that they had been doing. But they realize that copying only gets you so far, and they have vastly improved their patent system, and they have zigged while we have zagged. Unfortunately, in the U.S., we haven't gone where we have due to intentional industrial policy. It's really just been as a result of lobbying on the part of certain companies that don't have the interests of the greater society in mind. It's also interesting to note that some multinationals choose China as a venue for enforcing against other multinationals. It's not as advantageous to use China as a way of going against a Chinese company. But if you're a multinational going against another and you have a choice of the US, China, or Europe, many are choosing China, which is interesting. So the non-practicing entity problem has been willfully overstated, as I mentioned earlier. Besson and Murr created a study that's frequently cited of $29 billion of costs to our economy. This work and much of their previous work was discredited. They looked at the change in market capitalization when the suit was started, but not later when it was adjudicated, and many, many other problems. It was also cited by the White House report and others. And interestingly, the GIO study of the issue did not find a PAA problem, although no journalists seem to have found the GIO study. So we have a misinformation echo chamber. Winston Churchill said, "A lie gets halfway around the world before the truth has had a chance to get its pants on." And the mainstream press reads other mainstream press, and so do most people and Supreme Court clerks. So it's important to debunk the false claims which are still echoing today. So the search for terrestrial intelligence continues. Trolls are a problem, but it's hard to legally distinguish them from the righteous ones that I mentioned earlier. And legislation should target behavior. As I mentioned, the problem has been willfully overstated. The rise in litigation has other causes, including the AAA. Patent trolling is not new. It's been around. In the 1800s, they were called patent sharks. They'd go from farm to farm seeking licenses for patented farm implements. And there have been several SCOTUS rulings that have been setbacks to trolls and all other patent holders. And the Judicial Conference amended the rules to eliminate Form 18, which made it really easy to file patent lawsuits. So there's a lot of things that have reduced this problem. But it is also the case that disinterested experts overall are against more anti-troll legislation. Arguably, the AAA exhibits the wrong way to make sausage. So the right way, the 1952 Patent Act was written by two experts who studied the issue over 4 years. Pasquale Federico, the chief patent examiner of the PTO, and Giles Rich, who is a patent lawyer and later a patent judge, went to Harvard, smart guy. They had no vested interests or conflicts, and it passed both houses of Congress without debate. It was simple and clear, it had 35 pages, and led to huge success. In contrast, in 2011, the American Invents Act was written by lobbyists and staffers who are non-experts with vested interests. It was long, complicated, and ambiguous. It excluded the interests of startups. It was a result of long negotiations between pro-patent pharma and anti-patent big tech companies, but the interests of small companies were not at the table, and we got rolled. So Leonardo da Vinci said, "Simplicity is the ultimate sophistication," and this is not sophisticated. So some of the staffers were mostly dilettantes with little time. Many are looking to join the lobbying firms that are lobbying them. I know of one who did, who joined Intel afterwards. And the legislators themselves are even less equipped to deal. So there are provisions snuck in that few even realize. So, for example, an innocuous line in the Innovation Act that did not pass was this one, striking subsection F, which basically protected a guilty infringer who's using an unreasonable defense from the possibility of a fee reversal, i.e. make it easier to assert false claims of prior use without penalty. Ambiguity leads to more lawsuits. When litigants can mutually anticipate what courts would decide, settlement is more likely, but uncertainty leads to more litigation. And some of the ambiguities in the American Invents Act, for example, it uses both the terms otherwise available to the public and disclosure. And what the difference in them means, unclear. Same with subject matter disclosed and the claimed invention. Other issues have yet to hit the fan. For example, the grace period problems. So attempts to fix the problem may make it worse due to the 100-to-1 differential in lobbying power on the part of the anti-patent crews. Most problems begin as solutions, and so I'm careful, but we have to try. Good legislation won't move until Congress becomes aware and the opposition, the corporate opposition, grows a conscience. After much thought, nobody's come up with a perfectly just patent system, and I can't think of one. And so then the question becomes, whom to allocate the injustice? So my answer is away from the precious, fragile, and valuable thing that we have in America, the startup ecosystem, and toward large infringers whose expenses might rise by 25 basis points, which would make a tiny dent in their profitability. I've postulated an ISO injustice curve. One axis is injustice allocated to the plaintiff, and the other injustice allocated to the defendant. And the 2015 Innovation Act that did not pass, its effects would have shifted injustice from the defendant to the plaintiff to the inventor. What we should seek is to move the whole curve, or to move to points off the curve to lower levels of injustice all around. One might choose a little more injustice for the plaintiff if there's a lot more injustice for the defendant, etc. You have to ask who benefits. If your company could lobby the government to relax pollution rules such that it would harm people, most people would consider that unethical. If your company could lobby the government to lower your patent defense costs, but doing so would prevent funding new cures and medical devices and more people would die sooner, I allege that's also unethical, or in Google speak, that's being evil. Speaking of Google, why are they so anti-patent? Well, it may be due to one of my companies that sued in 2002. GoTo.com, later renamed Overture, invented the paid search model, and GoTo missed the filing deadline on core IP by 1 day. But they did patent some of the secondary stuff. Google copied what they did, improved upon it, called it AdWords, and then the lawsuit from the secondary stuff resulted in a settlement of 2.7 million shares, which was pretty good. But this now composes their main business, so the main source of revenue for Google is effectively stolen. Another dishonorable mention, Comcast, also known as Xfinity, their main business is cable modem service from copied IP that I mentioned before. The video business's main claim that they talk about in a lot of their ads is voice control of TV. That was copied from a startup named Promptu, and the patent suit is in progress. Disclosure, I've been an investor in that company since 2004. Apple also, after failing to get Samsung injunction on their blatant copy, and after Google's acquisition of Motorola's patents, which was kind of a check in the game of chess sense of the word. So then they settled in 2015, and the settlement release at the end, it said, Apple and Google have also agreed to work together in some areas of patent reform, i.e. to work together to continue undermining the system. You should look at their rotten treatment of Valencel, especially at the PTAB, where it filed 13 petitions against that tiny company. Tim Cook said famously, what kind of world do you want to live in? He said that regarding Facebook. Well, the same question should be applied to Apple and all of the other anti-patent crusaders. To paraphrase a famous quotation, if you want to test a company's character, give it power. Powerful companies are misusing their power. And I allege that the destruction of the patent system brought about by these big companies and their trade associations are the single worst thing they have done. Many lives will be lost from this, and the current Techlash is misplaced on issues of lesser importance, I believe. I think that this is the worst thing they have done and are continuing to do. And the cost of patent settlements had always been a rounding error for these companies. Company and government and policy people are on autopilot, and they don't see the big picture. Their pursuits in this area are mainly to justify their jobs, and such people rarely admit errors or reverse. And the boards of directors of these companies, many of whom are friends of mine whom I've tried to talk to about this, and they're unaware that this is happening. It's not that they defend it. They don't even know it, or they deny that it exists. The ongoing weakening of the patents will be destructive of the U.S. patent-dependent startup ecosystem and venture capital. More than 10% of our GDP comes from VC-backed companies. And so the weakening of patent rights takes over 20 years for the effects to play out. By then, you're likely to have been in the hospital room for you or a loved one, wishing that someone had invented the cure that he or she needs. So in conclusion, we need legislation to strengthen the system. We need traditional opponents to reconsider opposing that legislation. We need antitrust laws applied to PTAB pylons and other similar misbehavior. Courts need better IP awareness and understanding of what's at stake, and you have a role to play. Use your voice to help fix all this. Thank you.